on the grounds only of religion, race, caste, sex, place of birth, or any of them. In my last class, we were looking at the meaning of the word only. That only means that only would mean that a single ground of discrimination of any of the 5 enumerated grounds, or a combination of any of them. So it could be sex and religion, or it could be sex, religion, race, etc. Mathematically, if you were to do, it would be a case of 2 C5, permutation and combination mathematically. So it gives you a large number. So that would be the kind of intersectionality. And please look at this word little carefully, intersectionality. That is, you could have multiple bases of discrimination. Now, intersectionality itself is an advance over the original theory of classification, because classification has inbuilt in it an understanding that you're comparing A with B, apples and oranges. It only talks of a binary between which there should be discrimination. Now, the idea of intersectionality, which of course developed in Western feminist thought much later in the 70s, imagine that you could have 3 bases of discrimination. A person could be a woman, she could be a black, she could be poor, right? Or a person could be white and male and straight and gay, whatever. Your basis of discrimination could be multiple. And how do I theorize a test for discrimination when there are multiple bases of discrimination? Now, if I look at it from the lens of the classification doctrine as it developed in Article 14, you will see that it's best suited when there are only A versus B. Okay. A is privileged, B is discriminated, and you are looking at classification. Now, 15 introduces in an implied manner intersectionality. The word was never used in Indian constitutional writing, nor has it been used in judgments till that date. But now that feminism has given us a word for it, I continue to use it. So, or any of them. So, or any of them allows that there could be a permutation or combination between 2 or more of those 5 prohibited grounds of discrimination. Now, what about the word only? Only serves to confine the basis of discrimination to one or many of those enumerated. Secondly, it does something further. That if I am discriminating, say, on the basis of sex and something else, and another ground of discrimination which is not one of my 5 enumerated grounds of discrimination under Article 15, then Article 15(1) does not get attracted. What do I mean by that? If you take the cases of adultery, and I'm going to very quickly run through all the 5 cases and culminating in Joseph Schein today, it sort of explains my point. You have an early 50s case, Yusuf Abdul Aziz. I hope all of you have read the Joseph Schein judgment and come. If you haven't, I strongly advise you to look at it. Now, in the Joseph Schein judgment, which is looking at the offense of adultery, what the 5-judge bench does is unanimously, but not with a single judgment. There is still a plurality of judgments. But unanimously, all the 5 judges strike down the validity of Section 497. Okay. And you have one judgment for Deepak Mishra, Chief Justice Deepak Mishra, Justice Khanwilkar, a concurring judgment of Justice Nariman, a concurring judgment of Justice Chandrachud, a concurring judgment of Justice Indulitra. Now, all 5 of them not only strike down Section 497, but interestingly, they also strike down the Saumitri Vishnu, Revati and the Kalyani judgment, all of them which are of the 80s and 90s provenance. Now, the reason that they do that will give me the basis of describing the word only. There was no discussion on the word only in these judgments, but there was discussion in Nargis Mirza and impliedly in Saumitri. So I'm going to discuss that a little bit with you. What exactly does only mean? Now, if you take the Saumitri Vishnu judgment, which is, I'm talking about Abdul Aziz versus State of Bombay, AIR 1951, Supreme Court, page 321. I repeat, Yusuf Abdul Aziz versus State of Bombay, AIR 1951, Supreme Court 321. And then I come to Saumitri Vishnu versus Union of India, which is the one I'm going to discuss a little further and which was actually struck down by the Supreme Court of Joseph Shine, which is AIR 1985, Supreme Court 1618. And then V. Revati versus Union of India, which is a 1988 judgment, 1988 to SCC, page 62. And then a more recent judgment, V. Kalyani versus State of West Bengal, which is 2012, volume 1, SCC, page 358. So you have 4 judgments, all of which have upheld section 497. I'm going to request one of you to tell me what exactly 497 deals with. Section 497, and quickly tell me why the Supreme Court struck it down. Yes, anybody? As well as 198 of the CRPC. Yeah, so can somebody just tell me? I'm just going to bring this one up on my screen. Has even one of you read it? Okay, now tell me, I've brought it up on the screen for those of you. Now look at 497. Yes, anybody, why is this unconstitutional? On general principles, why is it unconstitutional? And it's unconstitutional under 14. It's not been held unconstitutional under 15, except by Justice Chandrachud, who also held it to be unconstitutional under 15 as well as 21. But by and large, if you take Justice Indu Malhotra, you take Justice Nariman, they all are striking it down under 14. Yes, anybody, even if you've not read the case, just look at it. Whoever has sexual intercourse with a person, whoever can be anybody, whoever has sexual intercourse with a person who is and whom he knows or has reason to believe is the wife of another man, without the consent or connivance of that man, such sexual intercourse not amounting to the offense of rape. Not amounting to the offense of rape already indicates to you that it is consensual sexual intercourse. So, for example, if the wife is committing adultery with a man outside of marriage, it's not rape and therefore it is consensual. Okay? This other man is guilty of the offense of adultery and shall be punished with imprisonment of either description for a term which may extend to 5 years. Okay, where is my IPC? Okay, in such case, the wife shall not be punishable as an abettor. Now, if you take the Saumitri case, the 1985 case of the Supreme Court, are you all listening to me? Are you all there? Yes, ma'am. Yes, ma'am. Saumitri chose to focus on this. If you can see what I've just highlighted, the wife shall not be punishable as an abettor. Now, the wife is an abettor because she has had consensual sexual intercourse because it's not rape. Okay? There are just 2 buckets. Either it's consensual sexual intercourse or it is rape. There's either a yes or a no. There's no maybe in our rape laws. Okay, there's no in between. It's yes or no. Now she has said yes, and therefore it's consensual sexual intercourse not amounting to rape. She has committed adultery with her eyes wide open. Yet the law does not, A, she cannot be prosecuted for the main offense, nor can she even be prosecuted as an abettor. Now, when this was challenged in 1985 by the Supreme Court, Justice Chandrachud Senior, that is Chief Justice Chandrachud, upheld the law and he relied on the fact that the woman has not been targeted because, and he said an extraordinary thing which was quite, actually quite strange, and discussing it, Justice Nariman, if you read the judgment, it's well worth a read. It's well worth a read. He quotes Justice Vivian Bose in the first of the 5 cases that I took up, which is Yusuf Aziz's case. And there, Justice Vivian Bose, who is otherwise a very, very sharp judge, held that the last part of Section 497, which I've highlighted here on our screen, which states that women shall not be punished due to Section 1503. Okay. And the justification that Justice Vivian Bose gave is the woman cannot be punished as an abettor because under Article 15.3, every law is to be construed as protecting women. So, because under 15.3 the law can protect women, therefore, because of Article 15.3, this part of the law cannot be struck down as violating the right to equality. Now look at this very carefully. Under 15.1, you cannot discriminate on the grounds of sex. That's 15.1. Yet Section 497 clearly says that the wife is not an abettor. Now Justice Vivian Bose in Yusuf Aziz says that this is permissible because of Article 15.3. And this proposition that the non-criminalizing of the wife who is herself an adulterer or adulteress, if we want to use very old English, even though she has committed adultery, she should not be punished. It's because of Article 15.3, because you can have provisions that protect women. Now, Justice Nariman says that this is an instance, and I'm going to write it here and you can tell me what you think it means. It's a case of Homer nodding. Okay. I put it here too. Okay. And therefore, Abdullah Aziz, they upheld non-criminalization of women because of 15.3. Yet when I come to Homer nodding, anybody, what does it mean? Have you ever come across this phrase? Homer nodding? No, Homer is such a wise man. You've heard of Homer, right? Why do we know of Homer?
The Simpsons?
Sorry? Homer Simpson?
The Simpsons. Yeah, Homer is a character in The Simpsons.
No, not Homer Simpson. Please. I don't think Justice Nariman meant that at all. Which Homer do you think he meant?
Iliad Homer.
Iliad and the Odyssey Homer. Okay, so we go a little more classical in our allusions, not the popular cartoon. Okay, I like Simpsons very much. It's very droll and it shows that ugly American in all his ugliness, for sure. But that's not what he meant. What he meant was even such a wise poet like Homer, who wrote the Greek epics of the Iliad and the Odyssey, dozed off once in a while. And why did he doze off? Now look at these 2 grounds on which 497 has been upheld. And I want you to appreciate the differences and then come to the 5-judge bench decision. Okay, I'm doing this a little in detail because ideally this is how I would like to do all those 50 cases, but time is not on my side. So I'm going to pick and choose which cases I subject to closer analysis. Okay. Now, in Abdul Aziz, Justice Vivian Bose, he says Homer nodded off because 15.3 applies. What is the language of 15.3? It says, nothing in this article shall prevent the state from making any special provision for women and children. By its very nature, Justice Nariman argues that 15.3 can only apply to a post-1950 law because the state in question has come into existence only under this constitution, and therefore there must have been a law made after 1950 for me to justify the use of Article 15.3. But 497 is completely a pre-constitutional law, and therefore to use a 15.3 provision which is meant for a post-constitutional law to justify a pre-constitutional law, he says, is an instance of Homer nodding. He says, for example, look at Article 19.2 and look from Article 19.2 to 19.6. This applies to existing laws also. If you look at Article 19.2 and 19.6, it allows reasonable restrictions to be placed not only for post-constitutional laws but also pre-constitutional laws. So reasonableness of a law can be challenged. Even a pre-constitutional law can be challenged and upheld under Article 19.2 to 19.6. But if you are challenging the reasonableness of a pre-constitutional law, you can't use 15.3, which is only to be used for post-constitutional laws, and get away with it. That's why he says Yusuf Abdul Aziz is wrongly decided. Okay, I found Justice Nariman's judgment one of the best in the entire set of 5 judgments. Okay. But when it comes to Saumitri Vishnu, and I go back now once again to this, in such a case, the wife shall not be an abettor. If you read Justice Chandrachud, and now I'm reading Chief Justice Chandrachud, the senior Chief Justice Chandrachud, whose judgment, ironically, was overruled by his own son. So there was some element of irony in it, that the son overrules the father, etc. In any case, those are all just sidelights, human interest stories, not really legally a matter of interest. Yet, Justice Chandrachud, in his 85 judgment, upheld the sort of gender discrimination which is writ large in 497. It's totally gender discriminatory. Just look at it. If there's a husband and there is a wife, okay, there's a husband and a wife, and unfortunately I don't have a blackboard. These are the times that okay, let me just see. There's a husband and a wife. Can you see what I'm typing here? Is it visible?
Yes, ma'am.
Okay.
Yes, ma'am.
Now, if this husband woman, I don't know how. It just doesn't work. So I'm obliged to use this. Now, look, here is the husband having sexual relations with this unmarried woman. Okay, I put unwoman. Okay, meaning unmarried woman. Is he guilty of adultery under this? 497?
No, ma'am.
No, not, right? Because the offense is not actually the wrong that he has done the wife. The essence is the wrong that he may have done to the husband of the woman with whom he has had sexual relations. Because the essence of the offense is not marital relations but the property of the woman. So if he had, for example, sexual relations with the married woman, then H1, okay, this is H2 and this is W2, okay. He is having sexual relations with W1, who is the wife of H1. Then, of course, the offense of adultery will kick in. Okay. Likewise, if this wife too has sexual relations with, let's just call him a man, okay, a single man, unmarried man, or it can be a husband, H3, okay. It doesn't matter. This woman can never be charged with adultery. So the first layer of inequality is that if the man commits adultery, he can be prosecuted. The woman cannot be prosecuted. There's inequality at that level. Then there's inequality at the second level, that if this man, H2, has sexual relations with an unmarried woman, then though it is very hurtful, so the purpose of 497 is not the protection of marriage, but the protection of the wife in the marriage and the protection of the property of the man in the marriage, not the marriage itself, but the property of the man in that marriage. And his property is none other than the wife. So here H1 comes across as an aggrieved man. So, the American law makes, for example, a case distinction between fornication and adultery. So, if it had been H2 and an unmarried woman, it would have been the offense of fornication. Otherwise, it would have been adultery. Anyway, we don't need to go into all those details. Doesn't matter. Now, this is and then, of course, this woman, if she commits. Now, when you come to Saumitri Vishnu, and I'm wanting to explain the word only, which we look in 15.3. What the court says is, yes, there is adultery. There's adultery by the man and there is adultery by the woman. Because in this case, when he has adulterous relations, say, with the wife of another man, W1, then yes, there is adultery is complete. Yet, the court goes on to say that this man is the seducer and this woman is a victim. Because the judge goes on to say that no woman would willingly commit adultery. Surely she betrayed her husband and that marriage by being seduced by H2. So the logic of 497 is that the man is the seducer and the woman will always be what we call the dupe or the victim. Is to be discriminated only on the grounds of sex. Whereas when we look at 497, and I'm now talking about the 85 judgment, people who have zoned out or came in late, don't get confused. This is not Joseph Shine I'm talking about. This is a case of sex being a ground of discrimination here because a woman is not, but coupled with the fact that the character of Indian women is not to commit adultery, and instead they have been seduced by this wicked husband too. So the nature of Indian women and the reality of Indian life coupled with the discrimination of sex means that Article 15.1 does not get attracted because it's not discrimination only on the grounds of sex. It is sex coupled with something else. Now, we saw this already in Air India versus Nargish Mirza, that women, air hostesses, are discriminated maybe because they have to retire at 35, but 15.1 cannot be attracted because they are not being discriminated only on the grounds of sex. They also belong to two different cadres. Women are air hostesses, men are pursers. So the distinction between their conditions of service and the years of retirement and their conditions of work is based not only on sex but also on the fact that they belong to two different cadres. The fact that a woman has to retire when she has her marriage or first baby is not only on the grounds of sex, but also is to protect women's health. So it's sex plus women's health. So in these, what I can only say, extremely awkward ways, the Supreme Court upheld the Air India case because it was sex coupled with something else. So if you are looking at the word only in 15 One, it has to be sex and only sex. The moment you couple sex with the weak nature of Indian women who never commit adultery, and surely they must have been seduced by that other wicked man, H2, then you are saying that the reason this is not hit by Article 15.1 is because it's sex coupled with the Indian reality. Now, I've given you two grounds for justification of phone is where we rely on the word only, and we say that Indian reality is that women do not commit adultery voluntarily. Now, this flies in the face of sexual intercourse not amounting to the offense of rape, because this means that the woman consented. But the judge adds another layer of gloss and he says she must have been seduced into consenting. And that means you obtained her consent by fraud or inducement, which from your study of 396 means it goes back to being rape. It's not really consent. Anyway, those are the judgments. Now, when I come to the 5-judge bench in Joseph Shine's case, you will find that most of the judges strike it down under Article 14 on the grounds that it is straight away discriminatory against women, which is, of course, the simplest reading of 491. Because if they are having consensual sexual intercourse, then both of them are committing adultery. So, a provision that only criminalizes the man and not the woman is on the face of it discriminatory. Many of the judges took that. And in fact, if you read Justice Indu Malhotra uses the expression coverture. Have you ever come across this expression while doing rape? Coverture? What does coverture mean? While discussing marital rape? No? Coverture means... Yes, please. Somebody had under the protection of. And usually in English law, once a woman gets married, she loses her identity. Her property is merged with that of the husband and they become one. So if you look at the provision under, I'm not sure I'm saying the correct section 122 or 123 of the Indian Evidence Act, that I'm forgetting which the number of the section is, 122 or 123, that there is, if a man communicates something to his wife, that does not constitute privilege.
It is 122.
122, right? And the idea really flows from coverture that man and wife are one. So, it flows from coverture, something like an ardhangini in Indian thought, that you are merged with that of the husband. And therefore, they can be and therefore, because of she loses her identity, there's no way in which the wife shall be punished as an abettor. Okay, it flows from coverture. Now, most of the judges, as I told you, struck it down on grounds of Article 14 that discrimination on the grounds of sex was lit large, and they looked at 15.1, some of them. But Justice Chandrachud, Dr. Chandrachud, went one step further and he said two things, which is he said that along with Justice manifest arbitrariness. I'm reduced to using this as my whiteboard. Oh, okay. Manifest arbitrariness, that is, there is a lack of a determining principle. You remember we've discussed manifest arbitrariness with Justice Nariman in his Shaira Banu, and he repeats that here again. Anything which is capricious, which is irrational, and where there is no clear determining principle. There's no reason why the woman should have been not criminalized. So the lack of a determining principle amounts to manifest arbitrariness. Justice Nariman uses manifest arbitrariness to strike it down. Dr. Chandrachud uses this, he uses 14, but he also uses another ground which I think is interesting for us to substantive equality. He uses this principle of substantive equality. Okay, and this substantive equality, he says that we should move beyond formal equality. And you remember in my introductory classes, I made that distinction between formal equality and substantive equality as phrases we are going to use when we study the provisions requiring to equality. Now, what exactly does substantive equality or formal equality mean? In formal equality, we're just treating man and woman as one. Okay? And you can strike it down as violating formal equality because women obviously should also have been criminalized in 497. Then, if you strike it down on the grounds of 14, you're striking it down only on the grounds of formal equality. Why are you criminalizing the man? Why aren't you criminalizing the consenting woman also, who is also guilty of adultery? Because she had sexual relations with a married man outside of him. Yes. But he says, I'm also going to strike it down on substantive equality. And what is that substantive equality? The test of that substantive equality, he tells us, is what is the real impact of legislation? And he believes that this, if the impact of the legislation is to continue the subordination or the disadvantaged position of women, then it is violative of substantive equality because the function of the law should have been to lessen the disadvantage, lessen the subordination, but instead it is only reifying it and it is only strengthening that inequality. So in this particular case, he says 497, and I'm just using his own words, he says it perpetuates a notion of marriage which subverts the equality of the spouses. Because 497 is subscribing to a theory of marriage which subverts the equality of the spouses. Why? Because if a man has sexual relations outside of marriage, it doesn't matter whether it's with a single woman or with a married woman, or even with a gay relationship. In any case, any sexual relationship with any person is violative of the autonomy and dignity of the woman. And section 497, therefore, is strengthening that inequality, and therefore it should be struck down on grounds of Article 21, read with Article 14. So it says every law should either strengthen substantive equality, whereas this is only, if we strike it down only on grounds of formal equality, saying it doesn't treat men and women equally, that is okay. But instead, it should have been doing the reverse. It should have been addressing the need to redress the inequality. It should have been proactive, and therefore it's violative of grounds of substantive equality. So he uses 15 for that purpose. And then he uses 21, which is something none of the other judges have done. And I think that was perhaps what was very controversial, or not controversial, which received a lot of media notice. He says that a marriage is not like a prison. For example, so if any of the partners want to have sexual autonomy and enjoy sexual relations outside of marriage, they should be free to do so under consequences. He's not saying let there be adultery. No, that's not what he's saying. So we should not vulgarize what he's saying. He says if they chose to have relations outside of marriage, then the civil remedy of seeking divorce on grounds of adultery is there. There is no need to also criminalize it. Because the moment you bring criminal law in, you are trying to defeat their autonomy and dignity of each individual. It is their wish whether they want to get married. It is their wish whether they want to get out of that marriage. And merely because they had sexual relations outside of marriage, because they don't want to be in this marriage, the criminal law should not be brought to bear. The marital law is there, that marriage law is good enough to take care of the protection of marriage. So marriage doesn't need the heavy arm of criminal law to protect it. The matrimonial laws are good enough. Now, I looked at this case a little more closely to explain to you ever so many principles of equality that I thought are available here. Okay. And what are these? We looked at the distinction between formal and substantive equality. By the overruling of the 15.3, the fact that 15.3 is only applicable to post-constitutional laws. It cannot be used to defend pre-constitutional laws. That's his Nariman. And then that 15.1 only, which was used in the Saumitri Vishnu's case, coupling sex with something else. And the Catherine McKinnon article that I posted on our website very clearly explains the difference between sex and gender. Now look at these two words. Sex is a biological phenomenon. What we mean is...
You muted yourself.
Oh, I muted myself. Sorry. Now, it also makes a difference between sex and gender, the word only. So just see if you can follow the point I'm making. If it's discrimination only on the biological ground that this is a woman, she is being retired at 35, but a man who does the same job on an airplane is retiring at 58, then it's discrimination on the grounds of sex. The moment I add something else, that they have two different career paths, they have different promotional avenues, which is what happened in Arakesh Mirza's case, then we are adding sex plus something else, and then the word only will no longer be applicable. And therefore, the provision will not be struck down on 15. Therefore, they examined it only on grounds of 14. And as I mentioned in class earlier, most of these provisions were upheld. And if at all a provision was struck down within 4 years of marriage, they said, yeah, it's very good, family planning, okay, that kind of principle. Now, by allowing discrimination not only on the grounds of sex, but also on sex plus something else, like Saumitri Vishnu did. It said the social reality is that Indian women do not commit adultery. So even if a woman did consensual sexual intercourse outside of marriage, that other man must have been the seducer. Then you're constructing a reality of Indian women who are all these victims and who are poor things, bechare types, who are not entering into adultery at all. Now, because you are treating sex and a social construction of that sex, this is what we call as gender, which is a social understanding of sex. Women are the ones who must cook. A woman and a man is a biological category, but that society this is in the kitchen and they must cook, because that understanding and this is how women ought to behave, this is what women ought to do, is not a sexual category, but it's a gendered category because it's socially constructed. In that sense, Saumitri versus Vishnu is also a gendered understanding that Indian women do not commit adultery. They are only seduced or induced by these wicked men into committing adultery and forgetting their vows of marriage. Okay? And therefore, it is a gendered construction of women. So, all these judgments are trying to say that by having this social reality and by pasting it on Indian women, we are being unfair, and therefore Section 497 for not criminalizing women is not only against formal equality, it is also against rights of a gendered category. That is the way in which the social reality of women is constructed. Okay. Are there any comments or questions? Or am I sort of clear?
Ma'am, I have a question. Ma'am, you mentioned that in the Air India judgment, there were two
marriage and the fact that they belong to two separate cadres, air pursers and air hostesses, was also, it was not mentioned in as clear a form as I've explained it now to class, but that is there in the underwritten in the judgment.
Okay, yes. So now, like this case and many other cases, there is always an underlying, as you said, that there's an underlying, there's another aspect which is added, like women's health or societal, maybe gender. However, ma'am, these things can only be with women. Women's health can only be a concern to a certain sex of people, which is women. So, isn't that again coming inside the category of sex and then discriminating against it?
The thing is that, you have a very valid point, but health is something that I think could be gender neutral also. Eventually, flying long hours in the sky is disruptive of everybody's health, okay? Because, day and night get disturbed completely because you don't have a normal, what is called a diurnal circle, right?
Yes, ma'am, but then
all those things are there. No, you are trying to make the point that these are also facets of only sex. But if you take sex in its narrowest form, it is only the biological function, that a category called women. But that women's health and women's concerns or women's patriarchal positions in society will make it a gender construct. Because you're adding another layer to just that biological category.
Ma'am, definitely. But again, say we are trying to protect pregnant women. Now, women are the only sex which can get pregnant, if I'm not wrong. So that again, it comes under the category of sex and not so much as gender, because a person can
I agree with you. I'm just to be brief on this point. If you look, one of the only categories that sort of pregnancy is, of course, peculiar to women, and so pregnancy, should it be a ground for difference or sameness? Should we take women and pregnant as one category? But if you take, for example, things like Chiranjeev Talu. Sorry.
I'm sorry to disrupt you, ma'am, but I'm just saying the sex, the biological category, the sex which is female. Yes. Those are the only people who can.
I know what you're saying, but I'm just trying to address your point that maybe what you're saying holds true for pregnancy. But the moment I broaden it to something which could affect men also, and health is a broader category. Okay, so there have been attempts, for example, when you look at Ration Negligent Act and you look at Kishore Alwalia's case, whether premenstrual tension should be a category which is only a woman, whereas long periods of stress resulting in its outpouring in a violent act, which is really the essence of Alwalia's case, right? Which I'm sure you studied, the Ration grave and sudden provocation, I beg your pardon, not Ration Negligent Act, grave and sudden provocation is something that could as well affect men as women. So pregnancy perhaps is the only other category which is completely attached to the biological category of sex, but not anything else. So child caring and child rearing are not gendered because they could be ungendered and unpacked. You could have men, and there are men who are very nurturing and caring and can look after children. So to say that this is somehow a feature of a woman would not be correct. So I think apart from the biological category, the only other one that I could attach would be pregnancy, but not child caring or child rearing. If you say that a woman must be it is something that could equally be attached to man. Are you following what I'm saying?
Ma'am, yes, ma'am. But my doubt is that since they did not give that leave or that leeway to the men were still flying even after they became fathers. There were no restrictions on them. There was no concern for them that they should be the ones caring for the children. Therefore, they should also have, because I'm sure a father would also want to be involved in their child.
True. I agree with you.
Ma'am, and second point, if this is what we are going with, then in Sabrimala case, when they say menstruating women,
Yes.
so it's not just women, right? It's not just sex, but also there's another category that they should be menstruating. So would we say that this is again not
it's interesting your question, because when I come to the there are three sets of judgments we're going to look at in Sabrimala, but you take the first one. The fact that women alone menstruate and therefore can be the only grounds for keeping them outside a religious place. The court uses 17 to strike it down, but not 15. Are you following my point? They say it's a form of untouchability. And untouchability needn't be only caste-based, it could even be. So both Justice Nariman there uses 17 to strike it down. But this more interesting point that you are raising, whether menstruation, since it is applicable only to women and of a particular of will it be treated as falling within the word only or not? They didn't have discussion on that. Now, the erroneous judgment is deeply troubling at ever so many levels. Okay, ever so many levels. And if you read the judgment carefully, what they do is they don't finally come to a holding on 15. They go back to 14 and justify it, saying 35 years is justified because men and women form a different cadre. First age of marriage, postponing it for 4 years, also they do, saying it's very good for family planning, even though men, there is no embargo on when men should get married. After all, men also may get married and have children. So if family planning is the concern, you should have had a similar law for men. But the court doesn't have anything to say about that. Okay, because one of the reasons is not that they didn't think, it's also to do with the limitation of a judicial role. You can only speak on the actual case in front of you. You cannot create a hypothetical case and say, because I'm upholding this rule of men, please make a new law for men also, not allowing them to get married. That is beyond the judicial brief. The court does not have a creative function in judicial review. It only has, if you call it, a power to destroy. It doesn't have a power to create. See what I mean? Yes, they cannot do that which you would have.
Yes, I'll be super quick. So, ma'am, when we say that there are societal values attached to women, which gentrify them, again, in Sabrimala case, I think Indu Malhotra, Justice Indu Malhotra pointed this out, that since it is a belief that and the custom which holds that women of certain age should not go there because apparently they'll seduce the god, and the meditation will his meditation will be disturbed. Therefore, they should not enter the temple. So again, customs also come into play. So how are we then saying that it's only?
But just to be very brief on that point, Ananta, that the word custom was not accepted by the remainder of the 5-judge bench, because they clearly pointed out that law, religious law has its origin in its divine form and not from custom, because the origin of custom is always human made, whereas religion is always divine. And therefore, that if indeed the Lord at Sabrimala was a male Lord who was a brahmachari, they were, if you read the other 4 judgments, some of them said it's only as recent as 150 years. And then there was this judgment of Justice Chandrachud, where he talks about the ghost of Narsua Pumali. Can personal laws be tested on the anvil of fundamental rights? Are they custom or not? And you know that position that religious personal laws are distinct from custom. He clarified that point. So, on that point, I see divergence between what Justice Indu Malhotra did, where she talked about custom, and the judgment of Justice Chandrachud, where he talked about the fact that the provenance of religious personal laws is actually uh, not custom but divine in origin. And that entire section in his judgment, the ghost of Narasu Appumali, I think you should read again. Okay.
Thank you, ma'am.
Okay. Now, I would enjoy discussing this more, but we are running short of time. So you don't have to agree with me. I don't say that at all. But it's my duty as a teacher to point out to you that difference between custom on the one hand and religious personal laws. So I would advise you to read both the minority decision of Justice Indu Malhotra on this point, okay, as well as Dr. Chandrachud's judgment in Indian Young Lawyers, whatever. Okay, now let me take attendance. I'm going to just to announce for those of you now in the class. Tomorrow morning I have a meeting. I'm sorry, I will not be able to meet you back, but I will take my class, and I will take my class at 5:30 in the evening. Okay, so I expect you all to be